Yes, hello? Yes,
Hi,
hello?
Henry. Line's open. Go ahead.
Yes, thank you. So this is Dr. Ree, otherwise known as the whistleblower. So it's nice that Gloria Castro has given us this presentation because it really brings everything together. She gives a wonderful, informative presentation, but in fact, she's lying. She's lying, and I know this firsthand because in my case, what happens is this, is that, for example, if the patients in question are being seen by internal medicine, the notes are done in internal medicine notes, that sort of thing, and it's written in a form which goes over organ systems versus presentation or that kind of thing. What they'll do is they'll spend a lot of time finding an internal medicine physician to support their allegation against a physician. And if they're not able to find them, what they'll do, as in my case, they'll lower the standard, lower the threshold, and find someone from another specialty. So they found a family medicine physician who failed to get his board certification. And even on the witness stand, he admitted that he's not familiar with internal medicine. These are not the type of patients that he sees. And the judge stated, well, standard of care is the same across all professions, but of course it's not. The standard of care for a palliative doctor is not the same as a pathologist. But what the DAG does is they'll just go get whoever to support their case. So what we're hearing from Gloria is actually false information. What we just witnessed is, false statements. And it's hard for me to say because she sounds so articulate and kind and succinct and logical, but it's what we witnessed. And of course, she didn't mention that she's currently a defendant in an ongoing federal civil rights lawsuit. It's been going for 3 years. It's still in the courts. It has not been dismissed. And she's being sued because she manipulates the law to work against the physicians of color. And it's just their standard of practice. I mean, I actually am not criticizing her because I've accepted the fact that, the DAG office is just corrupt. They alter information. They lower the standard of care.
15 seconds remain.
Yes, thank you. And so what they do now is they target physicians of color, call them mentally ill, so it goes on their NPDB reports, and they're labeled as such. It's just their standard of practice, and that's where all the money is going. Thank you.
Thank you for your public comment. Next up, we have Eric Andrus. Eric Andrus, are you there?
I'm here.
Go ahead.
TJ, I'm going to illustrate your point for you. First, it's interesting that Gloria said doctors will be disciplined when Carrie just said yesterday that the board can't punish doctors. Remember Panel A members when Carrie said that? So who's right with these dueling attorneys? It's clear that clearing an accusation from the rolls so the board doesn't incur unnecessary court costs often takes precedence over the standard of care. I didn't hear Ms. Castro speak to that, but we all know that's a regular occurrence. The system doesn't always work. You should have had a medical expert speak to this and make a comparison to the real-world workings of the standard of care, not the ideal one that people like Ms. Castro quote to make the board and the AG's office look good and like they're just doing their job. Let's take my case, for instance. I had 2 hernia surgeries, both of which failed. The surgeon wanted to do a 3rd surgery, but I no longer trusted her, so I went to a different surgeon for a second opinion. He did a slew of tests that found that the first surgeon left me in really bad condition. He did a corrective surgery on me and found that she had actually done the surgeries wrong and had sewn my stomach to itself instead of to the esophagus in a procedure called a full Nissen fundoplication, rendering the original procedure useless. He notated this in my medical records, and I provided that to the medical board in my complaint against the original surgeon, Dr. Kulmeet Sandhu of Glendale. But as is commonplace with this board, they closed my cases stating that the doctor had not violated the standard of care. So if you think about that, They're actually saying that sewing my stomach to the incorrect place in my abdomen, leaving me with a lifetime of ongoing stomach problems, is what all other doctors would have done as well. How many of you agree with that assessment? And how many of you who think that that sounds suspicious will look into my case and see why they actually closed it? I say it's retaliation for speaking out against the board, just like Jenna Jones is doing now with every complaint that I file. So the standard of care be damned. Also, some of these definitions she provided, good God, they're so out of date, no wonder the things are going bad. The general standard of care definition comes from a case that took place in 183 years ago, and the definition of gross negligence is beyond bizarre. How is an extreme departure at all the same thing as the want of even a scant care? The want of even a scant care can be translated to the need of even minimal care. How is that the same as an extreme departure? They appear to be opposites. Note that there is no code section quoted for the definition of gross negligence. It's clear that the standard of care, as Ms. Castro defines it, is more of a hindrance to patient safety than it should be.
Thank you for your public comment. Next up, we have Marianne Hollingsworth. Let me open your line. Marianne Hollingsworth, are you there?
I am. Can you hear me?
Yes, please go ahead.
Thank you so much. My name is Marian Hollingsworth, and I'm a patient safety advocate. It seems to me from my experience, the standard of care is the personal opinion of your experts. For example, with the complaint in my father's case, the board expert felt that a doctor met the standard of care when he deliberately drugged my dad with antipsychotics and other sedatives without consent, and that led to his death. A reasonable physician would not do that, especially or informed consent, but your expert felt that illegal treatment was the acceptable standard of care. Harm should always be factored into standard of care. How can it not? Considering that this board only disciplines 4% of complaints, ones that include death or egregious harm, I hope you will in the future train your experts so that the standard of care expectation is consistent. I should point out that the doctor in my complaint later showed up in the death certificate project for the overdose death of another patient. That patient died just 6 weeks after I sent in an appeal of the finding in my complaint, warning that someone else will be harmed unless this doctor is disciplined. So in your conclusion, your experts need more training in what constitutes a departure in the standard of care. They should not go by the, well, everyone does it anyway train of thought. We should follow the true accepted standards. You should not wait for a second death to decide that the standard of care was not met. Thank you.
Thank you for your public comment. Next, we have Michelle Montserrat Ramos. Let me unmute your mic. Michelle Montserrat Ramos, are you there?
Yes, I am.
Please go ahead.
Good afternoon. I'm Michelle Montserrat Ramos. I'm a consumer watchdog. Firstly, Ms. Castro, appreciate your presentation, your service. Dr. Hawkins, we also appreciate your question. I would like to know how someone can die in a California hospital and their death is not even investigated. Where else in California can you die and there is no investigation, such as the Lloyd Montserrat case? We cannot agree with you more, Mr. Watkins. What I do have to say is that this information needs to be provided to consumers. I have asked for the very minimum over and over. I have asked that the training materials provided to the medical experts and medical consultants be placed into a video or a document titled, "This is what we are looking for when you file a medical board complaint." All of you have questions. How could you possibly expect consumers to understand how you need their cases presented so enforcement has all the information they need and a consumer protection outcome is reached? In the past, we have discussed this, and board members admitted that some cases are thrown out because they don't have the information they need. I always suspected that. This basic educational tool would help consumers. It would help enforcement staff obtain the information they need. It would cut down the amount of time it takes to investigate a case, and it would cut down the number of angry consumers, patients, and Californians who did not receive a fair outcome. I've approached you with this recommendation for years now. I really hope that our new executive director will enact a This is the information we need when you file a consumer complaint, video, or document at this time. Thank you.
Provide most of the material I'm going to present today in more detail. The presentation's objectives today are to have a high-level overview of the definition of the standard of care and the existing laws concerning the standard of care in the practice of the medical board cases. The determination of the applicable standard of care is one critical step in the analysis and life of an enforcement case. It is pertinent in the AG's exercise of the prosecutorial discretion it exercises, and it is pertinent to the medical board executive officer's decisions to sign accusations for filing, which lists charges at the outset of the case. To start off with, the general duty of care. We all have an awareness of this in our normal day-to-day. Individuals owe other individuals a duty of care in different contexts, and that is the definition. So for the general standard of care, it's a long-standing definition as well. And as you can see, the definition bases standard of care on the reasonableness and the circumstances under which an interaction between individuals occur. The medical standard of care, and you will hear us in our parlance using these two terms interchangeably, also as the standard of practice. We use these terms interchangeably, but in any event, whatever term we use, we consider the context of medical care and the treatment and the physician-patient encounter. As we all are aware, the doctor-patient interaction can take the course over a short or a long period of time. It can take place in an outpatient or an inpatient setting, in a crisis or a disaster scenario, emergency and urgent care, mental health, pregnancy. It could be a one-time consultation or a one-time course of medical treatment. Generally, non-alternative medical treatment is science-based. Because knowledge, research, and technology can and do change over time, the standard of care can and does evolve over time. And critically, there is a difference between doctors who are pioneers in the field versus doctors who are renegades. Science and knowledge does evolve. So the standard of care is measured from acceptable practice during the relevant time period. So while looking back and assessing what the doctor did, we also ask, at the time, what should the doctor have done? A previously acceptable practice can fall out of the standard of care, or an innovative matter of treatment not within the standard of care can be later accepted as the standard of care. Either way, the physician is measured by the applicable standard of care and the time period of the modality or the care that was being rendered. There are ordinary and generally accepted standard of care where there is no longer development in the accepted knowledge. Examples of this include things that are generally accepted as something that needs to be done, and it is within the standard of care, like the basic taking of a patient history and physical exam, setting forth a treatment plan with objectives, obtaining informed consent, a periodic review of the treatment's efficacy, and adequate and accurate medical record keeping. And finally, there is only one standard of care. It is not higher in a university setting or an urban setting, and is not lower in an economically deprived or rural setting. The expectations of licensees in the state of California goes without saying. The expectation is that they will practice competently and within the applicable standard of care. Physicians are not required to provide above the care that a competent physician would have done in the same situation given the same resources. And physicians are not permitted to practice below the care that a competent physician would have done in the same situation given the same resources. And again, the working definition of the medical standard of care takes into account the diagnostic and treatment process that the average prudent physician in a given community should follow based on the patient, illness, and clinical presentation. The medical standard of care specifies the appropriate treatment based on scientific evidence, medical community consensus, and in the community of professionals under similar circumstances. The medical board receives complaints and investigates what the physician did in the care rendered to the patient. And this involves obviously getting into the time of care and those things surrounding that time and place. This involves review of medical records, patient interviews, sometimes asking for the physician's side of the story at the outset or later on with a medical consultant during an investigation to obtain the factors that set forth the medical decision-making. The standard of care is determined by experts in the same community involved in the treatment of the given condition, like the accused physician. The standard of care is not written down, however, it is defined in law. Business and Professions Code Section 2334 defines a professional conduct to include gross negligence, repeated negligent acts, and incompetence. The legislature enacted this statute and provides the medical board with the guidance it needs in handling licensees it is charging with unprofessional conduct. The standard of care is provided in expert reports and testimony of expert witnesses in the same specialty as the accused physician. The definition of gross negligence is set forth here. And again, this is the degree of a departure is determined from the standard of care applicable, and the degree can be simple, extreme, and at the same time, medical board experts can decide that there is no departure from the standard of care. The legislature has defined unprofessional conduct to also include repeated negligent acts. And a simple departure is set forth here. It means just a failure to use that level of skill or knowledge that another reasonably careful physician would use in the same or similar circumstances. The legislature has enacted further definitions with respect to an initial negligent diagnosis being followed by an act or omission that is medically appropriate. And this constitutes a single negligent act. The board will not charge a standalone, single, simple departure from the standard of care in an accusation, but it will charge repeated negligent acts. The legislature has also enacted incompetence as in professional conduct under 2234. And this is the definition. This statute takes into account that the level of competence required in providing medical care is expected to be reasonable, skilled, and diligent. In other words, a physician can possess the knowledge and ability to perform a procedure and be negligent in performing that duty in that procedure. At the same time, if the physician never possessed the knowledge and ability to begin with and still chose to undertake that procedure, that could be incompetence. That's the critical difference between negligence and incompetence. Physicians are expected to competently practice medicine within the experience, qualifications, and ability that they possess. And practitioners are trusted to practice within their competence and within the standard of care. Beyond CME requirements needed for licensure, professionals are trusted to maintain records, explain procedures and pharmaceuticals, obtain informed consent, be aware of diagnostic testing, medical knowledge, and changing or evolving standards of practice in California. And incompetence is determined by reviewing experts. And what we see with experts in their opinions is they'll say a physician lacks the skill or lacks the knowledge or is practicing outside of their specialty area or failed to meet specialized standards of practice and training. Ultimately, the elements of expert testimony set forth the expectation. The standard of care is a matter within the knowledge of experts. An expert testimony is required in medical board matters to prove or disprove that a medical practitioner acted within the standard of care, unless negligence is obvious to a layperson. Expert testimony is based on such matters as may be reasonably relied upon by an expert in forming an opinion on the subject. This is set forth in case law. In cases relating to medical care, the medical board establishes both the appropriate standard of care and is held to maintain their burden to show that the standard of care has been breached in order to be able to impose discipline. This is done through expert testimony and by qualified experts. And the standard of proof in these cases is clear and convincing to a reasonable certainty. Of course, an expert's opinion can be In medical board cases, the applicable standard of care is determined by in-practice and qualified medical experts. They must be familiar with the functions and duties expected by clinical practice and evidence-based research regarding the medical treatment in question. Experts generally testify on the community standard of care. The expert assigns the degree of departure from the standard of care, and this assists in determining the causes for discipline, and if the charges are sustained, the degree of discipline to be ordered under disciplinary guidelines. For the medical board, the charging document is an accusation. As we all know, HQE drafts the accusations and proposes them for filing to the executive officer of the medical board. The executive officer of the medical board decides whether or not to sign the accusation, and the charges at the time of filing are based on the available investigative evidence. And the charges in an accusation obviously go through the due process procedure set forth in the Administrative Procedure Act, which includes discovery, expert reported exchanges from accused physicians. Patient treatment outcomes are important to consider in this setting. Sometimes the patient suffers no harm and no injury, yet the physician's action can involve extreme departures from the standard of care, and they will be charged and they will be disciplined. At the same time, some cases with significant patient injury or death may result in experts finding no departure from the standard of care, or just one simple departure from the standard of care, which can't be charged. Patient selection, such as where risks and benefits to the patient are relevant, in assessing the applicable standard of care. Complications from the care or treatment, especially when they are foreseeable and part of the informed consent discussion, are usually not determinative of the degree assigned to a departure from the standard of care. That a medical board is held to show that the departure from the standard of care and the degree of departure, whether extreme or simple. In an incompetence case, the medical board may additionally show that the patient was placed in undue jeopardy and that the risk outweighed the benefits for the particular patient. The caveat to this slide, of course, is Business and Professions Code Section 2228.1, that provides for probation notification to consumers. In specific carve-outs, such as with multiple patient overprescribing cases, patient harm is assessed through the expert opinion only to determine whether or not the physician would need to notify patients that they are on probation. And that's how that law was written, and that is how experts go the extra step to determine whether probation notification is in order. In addition to Business and Professions Code Section 2234, the medical board and all other healthcare oversight agencies can take the extra step of promulgating regulations that further interpret law. Yesterday you heard about regulations with respect to medical assistance. That is a perfect example of regulations in play, interpreting the scope of a physician's duty to supervise underlings. Where a law is clear-cut, a reviewing attorney can assess whether the law was violated. For example, 2266, which is the statute that dictates that the failure to maintain adequate or accurate records is a violation of law. But from time to time, a Deputy Attorney General may still enlist an expert to assist them in reviewing the law. And in most cases, though, the decision to charge a violation of law is made by HQE. Guidelines, such as the medical board's published pain prescribing guidelines, are not considered the standard of care. However, a reviewing expert, in your case, can recite that the standard of care is consistent with those guidelines, or that the guidelines mirror what a reasonably prudent physician would do under the same circumstances. Again, the standard of care is determined by qualified experts, and this goes for both sides of the equation, prosecution and defense. Ultimately, upon the filing of accusation, we encounter the battle of the experts. In discovery and litigation processes, opposing experts on behalf of the licensee will be disclosed and will present their own application of the facts of the case and their opposing consulting's expert opinion on the applicable standard of care. And again, we have a law on the books, Business and Professions Code Section 2334, requiring exchange of expert opinions in a case, that before hearing at OAH. and this assists in the determination of the administrative law judge's subsequent issuance of proposed decisions to tell us which side presented the most convincing version of the standard of care. And ultimately, the medical board is the decision maker, and they consider proposed decisions and they issue the final decisions. And that concludes my presentation. Thank you.
Thank you, Ms. Castro. That was great. It's something that we have been wanting to have for a little while, and I think you've been very thorough in helping us understand these terms and these terms in current day. So I want to open it up to members for any comments or questions to Ms. Castro.
And Ms. Pines, Dr. Thorpe.
Okay, Dr. Thorpe.
So Ms. Castro, you said that I'm a little confused because you said that there is only one standard of care, and yet it appears that the standard of care is actually determined by the medical experts. And when the medical experts don't agree, which if you have opposing experts that are not going to agree, then the administrative law judge decides between the two which is the standard of care.
That's right.
So there is more than one standard of care.
Well, there's only one that would matter for the decision making. So in the community of practitioners, ultimately, in a case where you are looking at both sides, what the applicable standard of care is decided upon by the presentation of those opinions.
Thank you.
Thank you.
I have
any other members? Okay, go ahead. TJ?
Yeah, you mentioned, hey, Gloria, you mentioned that we will have repeated negligent acts, right? And we will charge that. Does that mean that repeated negligent acts is with one patient or with multiple patients?
It could be both, but for the purposes of the example here, it could be multiple simple departures. None of those can add up to an extreme, so they stand alone. So they fail to maintain records. They failed to put together a treatment plan and check in on the progress of the patient. Both of those standing together, let's say, could be individual simple departures. Repeated negligent acts can also take the place of, if you look at slide 8, for example, an initial negligent diagnosis followed by an act or omission medically appropriate for that negligent diagnosis shall constitute a single negligent act. So where the practitioner goes on path A and continues for a couple of steps on path A on that wrong diagnosis, that's one simple departure. Let's say they change their route and decide on a different route, and there they do it again wrong. Those two would each be simple departures, so you'd have two. And when the standard of care requires a change in the diagnosis and requires a reevaluation, if that doesn't happen, that too can be a departure. The fact that the physician didn't recognize, let's say that route A, the treatment was not having efficacy. There would have been a time where that practitioner should have identified that it was not working and gone back to the drawing board, redrawn their plan for the patient, and then taken a different strategy.
Thank you. So my second question is, because this pertains directly to how I assess cases. You mentioned that there's an applicable standard of care, but that applicable standard of care is determined by a community standard of care.
Yes.
And then on top of that, that becomes variable when described by two different experts. So two different experts can come from the same community where the standard of care is practiced and have differing opinions about what that standard should be. And then it just comes down to personality and presentation from the experts. It appears like that. Maybe you can clarify that for me.
Of course, sir. One would take issue with it being based on that. Obviously, someone who presents better and is calm on the stand, right? They're going to be able to present their facts in a calm and reasoned way. But leaving that aside, it's not a popularity contest. Ultimately, we do demand to see CVs. We do demand to know that this person, this expert, has actually walked in the shoes of the physician they are judging. So how many of those procedures have they themselves done? And when was the last time they did one? And these are the types of things that come out on cross-examination, both by the defense of our experts and ours of theirs. And ultimately, we are looking at where they went to school, where they trained, when's the last time, how many hundreds of these, did they write the textbook on the modality, were they part of that team that analyzed that and came up with however they're going to be doing this. It doesn't take a university setting in every time period, obviously. It could be just someone from the community. And back to there's only one standard of care, meaning the standard of care is not higher if you're a university professor and you come in and provide expert testimony on how you do it at the university. And it's certainly not when the country doctor comes in and says, well, this is how we do it in Visalia. There's only one standard of care, and that's the middle, right? So part of our presentation, we said that the standard of care is the expectation. Physicians are not required to go above, but they're not allowed to go below. So there is I don't want to call it a baseline because it's somewhere in the middle, right? Everybody meets halfway. I hope that makes sense. But yes, the experts' chops really do matter.
What's confusing to me is that I thought this was science-based, and it appears that science has some degree in it, and then it becomes down to, I'm not going to go as far as saying subjective, but it becomes very, okay, this is my experience, and this is my experience, and then to establish a community line through that, what you say, the middle line, I just think it becomes, it moves closer to a subjective opinion that someone can viciously defend. But, we all see these cases, and I'm sure some of us struggle with this because I cannot sometimes see how we get to where we got to, even with the DAG memo. So thank you.
Yes, and in fairness, by the time you see the cases, the standard of care may have evolved, right? It is judged by the time and place of when the care was rendered. So it could be 7 years from when the care was rendered or 3 years from the notice to the medical board. Either way, the physician is judged by the standard of care applicable at the time. So when I said, there's a difference between a pioneer and a renegade, someone can be already doing something that's going to become the standard of care in 4 years. That's not good. And sometimes that's the argument is, well, what I was doing at the time maybe was not generally accepted by the community, but eventually it became the standard of care. The way that we look at that is at the time that they did it, it was not the standard of care. So therefore, it is a chargeable issue. And while that might be frustrating, that is the expectation. The patient needs to be treated pursuant to the standard of care in the community at the time. It does not matter later on if it caught up or that there was no harm. The expectation is that anywhere you are, whether you're receiving free medical care from a member of your church who happens to be a doctor, or you have a concierge physician in a ritzy zip code, standard of care is the same. So And ultimately, the system works. I mean, we do bring in the two sides of the experts, and it gets talked out.
This is Howard.
Yes, Dr. Krause.
Gloria, thank you very much. And for my non-physician colleagues on the board and for the public, sometimes the public thinks that the practice of medicine is a science. While medicine can be viewed as a science, the practice of medicine is not a science. It's an art. I started life as an engineer where everything was precise. But in the practice of medicine, there's a great deal of subjectivity, subjective information provided by the patient, and subjective decision-making on the part of the physician. And that's why we can't draw a line and say, this is the standard of care by science, because the standard of care is really a community standard in a with a lot of subjectivity. And that is why our job on the board is so difficult, because we can't define it scientifically. Thank you.
That's right.
Gloria, Dr. Lewis, hi.
Hi.
Do you have something to say to Dr. Krause? Did I interrupt you? Hello?
I think I finished. I finished.
Okay. Gloria, I just have one question, because I got confused by one thing you said, under similar circumstances.
Yes.
So can you define that again, please? Thank you.
Of course. So again, it's doctor-patient interaction, time and place, and what you had at your disposal to use. So one example that we've used to try and discuss this particular point, Dr. Lewis, is you're a doctor. Again, I'm going to pick on Visalia. I apologize. You're a doctor in Visalia, and you are treating a patient who you believe requires a test. The closest provider of that test, let's say it's a CT scan way back when, and they were not readily available. CT scan is 40 miles away. And maybe you have an uninsured patient who perhaps is even non-compliant. The doctor should still recommend that test, whether or not the patient can afford it, whether or not the patient can get there. The standard of care would request that under similar circumstances, had that care been provided elsewhere where there was the machine available right down the hall. They were at a Kaiser or some other big HMO, and it was accessible. The standard of care is not lower for the doctor who didn't have the ability to send the patient readily to take the test. It's judged on similar circumstances. So whether or not you're similarly placed, the standard of care would still require that the doctor tell the patient, hey, go take this test. It's not, and record it in the medical record. And so that's how doctors are judged, basically. Had you seen this patient? They presented with the same symptoms? Have they presented with the same lab test objectively? And you as the physician thinking, okay, I'm seeing this patient. I happen to be in Visalia. I know that this test is not available. I'm still going to recommend it, and I'm going to document it. So similar circumstances. Same patient walking in at UCLA. I don't know if that helps to explain it, but that's really what that part means.
So I always use the example that, let's say you're in Modoc County, and then they don't have an MRI.
That's right.
And you're several hours away in San Francisco, but the standard of care is the standard of care.
That's
correct?
Right. Yes.
Okay. That clarifies it. Thank you.
Right. And so that doctor, whether or not the patient's not compliant, has the ability, resources, or the insurance, none of that. Doctor should still recommend it. Tell them, hey, you need this MRI. I'm sorry, but this test is, 400 miles away. You write it down in the medical record. And the doctor has met the standard of care by recommending it.
Dr. Hawkins, sorry.
Yes, please.
Thank you, Ms. Castro. This is very, very helpful. Can you tell us, all life is precious. Can you tell us how is that a death of a patient cannot be disciplined or a bad outcome not be disciplined? Why isn't it that someone must have done something wrong if the person died or if they had a bad outcome?
Yes, and I know that as I wrote slide 15, it comes across harshly for the same reason that the patient treatment outcome, harm or lack of harm, as well as what the disciplinary outcome could be for the licensee, revocation, probation, divorce, reports to the National Practitioners Database, they're not generally relevant to the standard of care. Sometimes the patient suffers no harm and no injury, and the physician can be acted upon with discipline and acted in a way with extreme departure. And sometimes significant patient injury or death could result, yet the experts could find no departure from the standard of care, or just one simple. Sometimes this occurs in the context of complications from the care or treatment, especially when they're foreseeable and part of the informed consent discussion. They're usually not determinative of the degree of the departure from the standard of care. So sometimes when there is patient demise, it's from a complication that was foreseeable. On the other side, Dr. Hawkins, sometimes when there is a bad outcome, the experts will look to the patient selection. Did it make sense for this 95-year-old man to get a TURP and diminish his quality of life instead of, going through some other less invasive route? A patient that has high blood pressure or has stroke risks. Just because you can do this procedure on a 95-year-old, let's say, you still have to assess the risks and benefits for this patient. So ultimately, those are the types of decisions that the expert really queries and looks at and to see whether it made sense for this patient to undergo that procedure. And sometimes in cases like that, where there is patient demise or the quality of life is such that they die or do not get the benefit that they were promised, and it puts them into a worse position than they were when they started, then that's where we do see that it matches, right? The harm matches the departure from the standard of care. But it's not always the case, and it is very disappointing, obviously, to everybody involved that for the purposes of the medical board licensing assessment, the harm does not figure in. And that's the way that the law is written. We do not also deal in the money part of it. I think the fact that there could still be discipline without harm goes to show that the disciplinary process is supposed to be preventative in some way as well. If the medical board only proceeded when there is harm, you'd only get a fraction of the cases. Since there is a rehabilitation component, you do want to proceed to prevent, not only to rehabilitate this physician, but also to raise awareness of other physicians who perhaps are doing the same thing and didn't know that it was a departure from the standard of care.
Thank you very much. And I deal with this all the time as a physician in private practice, the complexities of some of this patient care and outcome. And I appreciate Dr. Krause's comment about the art of medicine and the importance of really talking to your patient and having an understanding of what you're trying to accomplish, risk, benefit, et cetera. Thank you very much.
My pleasure.
Gloria, TJ again. That whole section that you just explained clarified a lot of stuff for me sitting on this board, and I'm sure for other board members. The concern I have is, when we are in that precarious situation, that information, and I'm sure this is not even related to your section, but just for a note on the side, that does not ever get communicated in the way where the public becomes aware, hey, this is what went actually down. Because a lot of the grievances that I hear on the public comment side has to do with people not having found out exactly legal reasons for why certain things happened in a particular way.
Mm-hmm.
And that would possibly be one factor that we could remedy downstream. Maybe not you, because your office is making this determination. This thing has been exceptionally clarifying and shed some light on some of the difficulties that we face. And Dr. Krause was very informative of making it known that it is an art and it is subjective, and you mix these the knowledge and what what the patient communicates. And I'm trying to think outside of the box about how we could make this system, and this is more of asking for help, how we could make this system a little bit. It seems so vague in some elements. And I know we all struggle with this, but I'm just trying to get a grip on it, at least parts of it, so that we can have outcomes that are, I'm asking the impossible, more predictable. But you gotta ask. Thank you, Gloria.
The second panel of the presentation, I went through your own materials, and it's interesting because sometimes it's there, but we just have to read it. And I would point you there, Mr. Watkins. There are resources on the website that perhaps could be more user-friendly, or you could read them and see if they make sense, because a lot of this is set forth there. I know sometimes it's not accessible to everybody, but it is there. And the other thing that is really great, and I would encourage every board member to attend, is the expert training that's put together twice a year at least for experts. And though it's not required attendance for experts at the medical board, if they do attend and complete an exercise, it does increase the hourly rate that they get paid. And this is all pretty much pro bono work. It's very, very, it's not compensated very highly, but it's very, very important that we train our experts. We do take the time to train them. And a member of our staff, Supervising Deputy Attorney General Matthew Davis, is one of the presenters. We have an ALJ. And we also provide the investigator's point of view and the defense's point of view as well, and sample reports. Because if it's something that needs to be explained to patients, it is also something that we need to keep our experts fresh on. And we explain some of these concepts in that training. So I definitely would encourage all members of the board to attend, and I know Dr. Yip would love to see you there.
Thank you. Are there any additional comments? Okay, let's move to, thank you so much, Ms. Castro. Again, very, very comprehensive presentation, something that we've been needing to sort of have. Questions I know I've had, and you've clarified a lot of that for us today. So thank you so much.
That makes me very happy to hear, and I'd like to acknowledge that I did show my presentation to Carrie Webb and also SDAG Matthew Davis, so I want to thank them as well for hearing out these points. And for just a very interesting article in the New York Times Magazine, August 9th, 2020, there is an article on COVID called Doctor versus Doctor, How Much Freedom Should Physicians Have in Treating COVID-19 Patients? The question has opened up a civil war in some hospitals. This was a great article because they're struggling with what is the standard of care for COVID-19 patients. It was fascinating, and it really gives you the struggle that these doctors are going through in establishing what is the right way to go. So I just want to make a plug for that. I don't know anybody on there, but I thought it was a good article.
Okay, thank you. I'll have the staff send us a copy of that article via email. Thank you so much for mentioning it. Host, can we have a call for public comments?
Yes, I've gone ahead and opened up the Q&A box there. The first request from Hannah Ree. Give me a moment to open your microphone. I could have everyone mute their microphones during the public comment so we can hear the callers as clearly as possible.